tuning in today with us. On behalf of the Sandbox Center team, welcome to our Experts in Residence session, The Legal Brief with Barristan Law. For those who haven't been acquainted with me or the Sandbox, I'm Mackenzie. I'm one of the 6 members of the Sandbox team. We're located downtown Barrie and online to connect people and their ideas to business resources on their journey to success. If you haven't attended one of our Experts in Residence sessions before, we're happy to have you with us. And for those returning, welcome back. Our Experts in Residence sessions are hosted monthly across a wide variety of expertise to help support businesses grow and succeed across the region. Now, given the current climate of COVID-19, the time of year and restrictions tightening in surrounding areas, the unknown of what's to come and how it's affecting the workplace is definitely a topic that can be seen lingering at the top of mind for many right now. Today, we are thrilled to have guest Josh Valler, Associate Lawyer of Barristan Law, and Janice Leroux, Founder and Partner of HR Performance and Results, join us to provide a summary of the changes experienced in employment law throughout the COVID-19 pandemic so far. They're here to discuss employer and employee rights and responsibilities and how they've been affected by the pandemic. We know some attendees today have pre-submitted their questions, but for those of you who have some questions throughout the session, please don't be shy. The experts are here to answer all of your questions. Use the Q&A feature at the bottom of the screen or the chat, and we'll be monitoring this throughout. We'll try to get to answering as many as possible towards the end of the session. Just wanted to quickly thank all of our community partners for supporting with the sharing of our events, and of course, a huge thank you to our sponsor, Barristan Law, for delivering today's session. So without further ado, we can get this started. Over to you, Josh and Janice.
All right, thanks, Mackenzie, and thank you to the Sandbox for hosting us again. It's been a couple months for myself and Janice at least, but it's it was great to kind of get the summer to see how some of the new changes to employment law were going to pan out. We're both happy to be here today to give a presentation. Janice, I don't know if you have anything you want to add.
Oh, just thank you very much to Josh and certainly Sandbox for inviting me to come join you again today. Looking forward to it.
Perfect. So without further ado, we'll start the presentation. So what we're going to do today is we're just going to go through some slides with respect to updates to different programs that were being offered by the provincial and federal governments to assist corporations and individuals through the COVID-19 pandemic. At the end of each section, Janice, I'm going to ask you to add your thoughts and any stories from the field, as well as providing some myself. And then, of course, we'll leave some time open for Q&A at the end. So the Canadian Emergency Response Benefit, or CERB, as it's so commonly known as now, ended when recipients had received 28 weeks of benefits on or around October 3rd, 2020, whichever came first. Canadians who had been receiving CERB through Service Canada will automatically be transitioned to EI benefits if already eligible. This had made widespread news, so this shouldn't come as a shock to anyone. Those who are receiving CERB through the CRA but are eligible for EI must apply through Service Canada. Those who are eligible for EI benefits will receive a minimum taxable benefit of $500 per week or $300 per week for an extended parental benefit.
So actually, maybe can I just jump in there, Josh, for 1 sec? Yep. If you go back to the previous slide, just maybe to explain to the participant group today that they made some significant changes to the number of insurable hours someone needs in order to be eligible for EI regular benefits. And so what they did was they lowered the threshold and then they gave everybody a one-time 300 insurable hours credit. And they increased typically unemployment insurance is 55% of your earnings up to the EI weekly maximum, which is $573 for 2020. And so essentially what they did was they locked in a minimum benefit individuals can be eligible for, which is the $500. But if someone's earnings is greater than that, calculated at 55%, then they can earn up to the 573 EI weekly maximum. And we anticipate that that's going to be in place for about a year or so. We're going into certainly, the summer of next year. So I just wanted everybody to be aware of those changes too as well.
Thank you, Janice. And certainly the timeline for that will be entirely dependent on the length of any second or third or fourth waves, the appetite from the federal government to continue providing the support, especially to assist individuals who are impacted by shutdowns to their respective industry. So we can go to the next slide, Jacklyn, thank you. And thanks to Jacklyn, who's also an associate at Barriston, you can't see her, but she's running the slides in the background, so much appreciated. So there's 3 new recovery benefits that have been introduced for those not eligible for employment insurance. To be eligible for one of these, you must not already be in receipt of one of the other recovery benefits: CERB, workers' compensation benefits, short-term disability benefits, or any EI benefits for the same week. So one is the Canada Recovery Benefit. Applications for this benefit opened on October 12th, 2020. It offers $500 per week for up to 26 weeks. It's available to workers who are self-employed, gig or contract workers, ineligible for EI, and who still require some form of income support. So this is really pertinent, I think, to this community and this industry where we have a lot of self-employed individuals who have their own businesses that otherwise wouldn't be eligible for employment insurance, but they've still been impacted nonetheless through COVID-19. Their revenues are down, so this does provide some much-needed assistance for small business owners. But to be eligible for it, you must include a COVID-related reduction of at least 50% rather, in employment or self-employment income. So you did not voluntarily quit from your job, but it was as a result of, as I said, a government shutdown of your store or your business as a result of some of the restrictions to curb the spread of COVID-19. We can go to the next slide, Jacklyn. The Canadian recovery, actually, before I do, Janice, do you have anything on the CRB that you'd like to add?
Oh, I think that covers everything, Josh. I think that the main thing that everybody needs to understand is if they're ineligible for unemployment insurance, and because the unemployment insurance insurable hours changed as well, there would be some people that would be eligible for unemployment insurance now that wouldn't have been prior because they've lowered that threshold. But that would be what I would emphasize with that.
Thanks, Janice. And the next benefit is the Canada Recovery Sickness Benefit. It's up to $500 per week for 2 weeks for workers who are unable to work because they are sick or are required to self-isolate for COVID-related reasons. Eligibility requirements include having been unable to work for at least 50% of your normal schedule within a given week because of illness or a requirement from the Public Health Office to self-isolate as a result of COVID-19. You have earned a minimum of $5,000 in 2019 or 2020, or in the 12 months preceding your first application. You aren't in receipt of a paid leave from your employer for that same week.
The key here too, Josh, is the 2 weeks. We're getting lots of calls regarding this. It's literally a one-time 2 week that you're eligible for this. So you can't reapply. You can take it one week at a time, but it's only for the 2 weeks. And so individuals who may have been required to go get COVID testing, and they're waiting for like 3-4 days to get the test results back, and as a result are self-isolating, then they can still apply for this particular benefit. It's going to be a lot faster to apply for this benefit opposed to if you go through the unemployment insurance route. What we've been told is it's taking about up to potentially 28 days to process claims right now still. But the key thing here is aren't in receipt of a paid leave from employer for that same week. So, you have a scenario where someone's getting a COVID test, they're self-isolating, they haven't gotten it back, they're off for 3 days. If as an employer you're paying for sick benefits, then yes, then they would be eligible to obviously through your program to claim, and they wouldn't be eligible for this particular benefit.
Yeah, and my understanding too is you can't pick and choose. If you do have paid leave available to you from your employer, you would not qualify for this benefit.
No.
So just if, for example, as part of your employment, you're given a certain amount of vacation time with pay and a certain amount of personal days or sick days. If you have those sick days still available to you that are paid from your employer, you would not be able to apply for this. The next one is the Canada Recovery Caregiving Benefit, or the CRCB. It's once again up to $500 a week, but this one is up to 26 weeks per household. For eligible workers unable to work because they must provide care to children under 12 or family members requiring supervised care due to the closure of schools, daycares, or care facilities. This one is one that will probably be pertinent to a lot of people with young families or with children that are going to school. My understanding right now is that if for a while, at least the beginning, if your child was exhibiting some of the symptoms of COVID-19, they were required to self-isolate and take a COVID test and self-isolate for a certain amount of time. This one really does impact or could impact a lot of households because obviously you can't leave your child alone. And this might be, in some cases, it might be more convenient for you to take care of your child because who else are you going to call? So this one is a really good benefit for eligible workers. The requirements for eligibility include that you're the only individual from your household claiming CRCB for the week that you're applying for. So if you have a partner, you both can't just apply for it. It has to be one individual, and you're not in receipt of a paid leave from your employer for the same week. So the same rules from the previous benefit would apply as well. And Janice, I'm sure you have something to add to that as well.
Yeah, the only thing I wanted to add, just from a scenario perspective, is that if you have an employee who's chosen to stay home with their children because of they could opt out of sending them to school, if they've chosen them to stay home, these benefits don't cover those individuals who have chosen to keep their kids home because there's no closure of the schools. They would be, in essence, be deemed to be on the infectious disease emergency leave under the Ontario Employment Standards Act, but there wouldn't be any sort of benefit that would cover them off just because they made a personal choice to stay home and teach their kids at home or at least monitor their children at home while they're on online learning.
Okay. So so my understanding from Janice, from what you're saying, there has to be some sort of proof or evidence that you weren't electing to keep your kids home from school at the outset, that you were required to do so, and they were in school initially.
Yeah, like because it's specifically as it relates to closure of schools, and if their kids don't have, if they're not ill or they're not vulnerable towards or getting COVID, which there has to be reasonable proof, right, of that. In order for them to be even able to apply for that particular benefit.
Okay, thanks, Janice. The next is the Canada Emergency Rent Subsidy, or CERS. This replaces the former Canada Emergency Commercial Rent Assistance Program. It provides rent relief to support small businesses directly rather through the landlords, because that was an issue that a lot of commercial tenants were having initially. Where they would like to apply for the initial program, but the landlords had some reluctance to do so. So this takes the landlords out of it, and it provides, as I mentioned, the relief directly to the small business. This subsidy will support up to 65% of eligible expenses for businesses that have experienced a drop in revenue, and up to 90% for those who are temporarily shut down by a mandatory public health order. In this region, it shouldn't impact too many businesses for the 90%, but certainly the 65% that businesses that, or for businesses that have experienced a drop in revenue, this will be a big support. The amount of subsidy businesses are eligible for will be proportional to the extent of their revenue loss. This program will run to the middle of 2021. Obviously, everything is fluid. We're seeing, less than a year of COVID. We've seen a huge transition from the initial programs and the rollout of the initial programs to kind of a more refined approach and a different approach now, approximately 7 months later. So it's worth keeping an eye on over the course of the next few months to see how these programs are going to continue to change. And by no means does this mean that it will stop in 2021, but it could be changed again depending on the circumstances at the time. The subsidy will be available to retroactively cover October rents and is expected to be accessible to small businesses in the coming weeks. It was announced that the Canadian Emergency Wage Subsidy, or CEWS, will also be extended until June 2021. So there's also the Canadian Emergency Business Account, which has been enhanced. The CEBA is a $40,000 interest-free loan with 25% of the balance being forgivable if certain conditions are met. Businesses that are already eligible may be able to obtain an additional $20,000 loan based on their needs, with $10,000 forgivable as paid by December 31st, 2022. Applications are handled through financial institutions, and the deadline to apply has been extended to December 31st of this year. So just a bit of an update on Ontario Regulation 228/20, the infectious disease emergency leave. This one's a really important one, and Janice, I'm going to look to you to touch upon this as well. But employers who had temporarily reduced hours or laid off employees had to bring them back prior to September 4th, 2020, to avoid any sort of constructive dismissal claims. Because in our earlier seminars, we had talked about the 13 and the 35 weeks, and that period had expired coming up to September 4th with layoffs that had to occur based on business needs and reduction in revenue. But the provincial government has extended this deadline to January 2nd, 2021, and it's very likely that this will be extended again. Such employees will continue to be deemed to be on job protected infectious disease emergency leave, or IDEL. So there's three options for employers who cannot recall employees prior to January 2nd, 2021. They can terminate the employment on or before January 3rd, 2021 and pay the relevant notice. Continue temporary layoff beyond January 3rd, 2021, at which point the ESA provisions would apply, 13 weeks and a 20-week period maximum for layoff, or up to 35 weeks per 52-week period, depending on factors such as benefit continuation. Continue employees on unpaid job protected IDEL, provided COVID-19 is still designated as an infectious disease under the Employment Standards Act, and the employee meets one of the reasons for taking the leave, i.e. directed to quarantine or isolate by public health, or employer provide support or care for family member travel restrictions. It's really important to note, however, that this protects a constructive dismissal claim under the Employment Standards Act. However, the common law would still apply. And this is a very tricky scenario where if you don't have a valid layoff provision in your employment agreement with your employee, then technically what they could do is they could argue that you were not entitled to lay them off anyway, because that was not contemplated in your employment arrangement with them when you hired them on. So it wouldn't matter that this leave has been extended, or the period rather has been extended. They're entitled to claim, regardless of what the government has legislated, that the common law applies, or the case law, and they're entitled to treat their layoff as a form of constructive dismissal and seek compensation or notice in lieu of reasonable notice, payment in lieu of reasonable notice rather, instead of being recalled. So Janice, I'm not sure if you have anything to add to that.
No, I think that's great, Josh. The only thing, I think a couple key points. The temporary layoff clock resets on January 3rd, so that everybody should be certainly aware of that. I think everybody also needs to be aware that this leave will be in place as long as COVID is considered an infectious disease, which at this point, not sure what that end date would look like. And I think, we're just highlighting certainly the changes only as it relates to this, the temporary layoffs, and that they'd be deemed on a job protected, on the job protected leave. There are other reasons that employees can request this leave. So just be very familiar from an Ontario Employment Standards Act perspective of when an employee can request to take this leave as well, because we've got a lot of employers where they've got a lot of employees who are actually off on this leave right now for various different reasons, right? So
yeah, no, thank you, Janice.
Yep.
So the mandatory COVID-19 screening requirements. So Ontario's stage 3 requirements, regulations rather, require employers to conduct employee screening for COVID-19. Employers should, at a minimum, use the questionnaire provided by the Ministry of Health to screen all employees prior, and this is very important, prior to entering the workplace. This can occur either verbally or in writing. This may involve posting the questionnaire with a notice at all entry points, requiring all employees and visitors to review the questionnaire daily prior to entering, requiring visitors and employees to submit the questionnaire daily prior to entering, or preparing a policy which lists the new or worsening symptoms from the questionnaire, and requiring all employees to review the questionnaire daily prior to entry. Employees should be advised that if they answer yes to any of the questions, they may not enter the workplace. Employees who answer yes to any of the questions should alert their supervisor, immediately return home to isolate, complete the self-assessment and contact telehealth at the number there to find out if they need a COVID test. Janice, did you have anything to add to that?
No, the only thing, unfortunately, we've been dealing with a lot of positive COVID cases with clients in Ontario. And so we have been really involved at the public health department level. When there's an outbreak in a workplace, which is essentially 2 or more cases, the public health department is highly recommending that the screening questionnaire is done in writing every day for the 14-day period of time. Outside of that, if you don't have a positive case in your workplace, then absolutely the screening questionnaire can be done verbally, but definitely like the recommendation is to put it in writing in a policy and post it at all of your employee entrances so that you are very clear that nobody should be coming into the workplace if they have any of the symptoms. And the advice is if anybody's experiencing any of the symptoms, it is they cannot return to the workplace until they're 24 hours free of any of those symptoms. So the minimum requirement is 24 hours. So if you don't already have that in your policies, then I would certainly recommend that you incorporate that in.
Yeah. And in a very big concern from a civil liability perspective too, is that if you don't comply with this screening requirement and there is a positive case at your office, or an outbreak at your place of work, and just say someone gets, God forbid, someone gets sick, either an employee or a customer, you know, you could be exposed to significant civil liability as well. There was a recent new piece of legislation from the provincial government that would protect individuals and businesses that are acting reasonably from civil liability attributed to any COVID-19 illnesses that are contracted at the workplace or at your place of business. But it would be very clear, though, that if you fail to comply with this screening requirement as required by the Ontario Ministry of Health and different public health offices, that you would not be considered to be acting reasonably and therefore would not be protected by that the immunity offered by that legislation. So very important to ensure that you're implementing strong COVID-19 screening requirements, and not only implementing it, but adhering to it every day.
Yeah.
So the Ministry of Labor audit for COVID-19 requirements compliance. So as you may or may not know, earlier this year, the provincial government increased its budget for inspectors from the Ministry of Labor to ensure that businesses are following the practices and procedures as set out by the Ministry of Health and the local public health offices. So inspectors will look for the following practices and procedures when they attend at a place of business: social and physical distancing measures in place, reasonable precautions when physical distancing is not achievable, screening measures, as we've just discussed, cleaning and disinfecting, hand hygiene, personal protective equipment, infection prevention and control. Janice, do you have anything to add to that?
No, I think maybe just in addition to that is in the previous slides too, as it related to screening, you mentioned certainly the legal liability from a civil perspective. There's also the liability under the Occupational Health and Safety Act. Mm-hmm. If an employee contracts COVID-19 in the workplace, then it would constitute potentially an occupational illness, right? So then, you know, you've got the 4-day reporting requirement. The Ministry of Labor inspectors would come in and do their investigation. So it's even more critical to ensure that you have in writing your policies and that you can prove that you've trained your employees because they are looking at all of these particular areas when they come in. We've also experienced if the Ministry of Labor is actually going in on a completely different matter. The inspectors we've spoken to, they're also saying they've been mandated to actually inspect while they're there addressing the other matter. They're looking at the COVID compliance requirements. So really important to be aware of that as well.
Mm-hmm. Thanks, Janice. So experience with positive cases of COVID-19 in the workplace. Janice, I'm going to ask you to touch on this one because I know in your work as an HR consultant and HR professional, you've been really instrumental in guiding businesses on how to deal with that positive case. So if you could just touch on that and your experience of that would be fantastic.
Yeah, so yes, like I mentioned, we've unfortunately, I'm going to say, dealt with quite a few cases at this point. So, you know, typically what's happened, and we've had kind of different experiences depending on the scenario, but it is as soon as someone notifies you, one of your employees, that they've been tested positive, then you should be acting immediately on basically on the procedure. So what we say is if they notify you in the workplace, obviously it's isolating them and actually directing them to go home immediately. And at the same time, ensure that you're interviewing them so that you can start the contact tracing process. Simultaneously, the public health department, depending on the region, is contacting them, and they're also doing their contact tracing process. They are contact tracing, identifying individuals that your employee would have been in contact with only 2 days prior to symptom onset. So let's say that employee notifies you on the weekend, they experienced symptoms, you know, on the Saturday. They get notified of their test results on the Tuesday, hopefully self-isolating while they're waiting for the test results. They're going to go back to the previous Thursday to identify who they came into contact with. And they identify basically who has been in close contact. And close contact has been defined as within the 6 meter distance. And then, you know, for 10 to, well, they actually, they just updated the guidelines, but typically it's been 10 to 15 minutes of uninterrupted time, but we're seeing and hearing a few changes in that area as well. And then it's ensuring that you notify your employees of certainly the individuals that have come up on the close contact list, notifying them that they've been deemed as close contact. I'm sure Josh can speak to the privacy piece, but we've advised all employers, do not release the information about the person who's tested positive. If the employees figure it out, they figure it out. And all the cases that we've dealt with, we've had everything from employees running around a building trying to figure out who's been absent that day to actually figure out who has been tested positive, because we've never released, obviously that information was never released. It's contacting, simultaneously you're conducting thorough workplace cleaning of that particular area. And we've recommended to notify employees that in that whole entire workplace that there's been a positive case. There is an obligation under the Occupational Health and Safety Act that you inform employees of workplace hazards. And this potentially is obviously a workplace hazard if it's contracted, if the employees contract COVID in the workplace, then it can constitute an occupational illness. So notifying employees, and then it's looking at the return to work process. It's 14 days. Basically, the public health department has advised us that there's enough research out there that even if you requested a negative test before they came back to work, that the virus can stay in individuals up to a certain period of time. And so it still could show up as a positive test, but they reassured us in all situations. And we've spoken to infectious disease, basically infectious disease experts of the public health department. They did say that the virus is not contagious any longer. And so the upper is the 14 days. That's why we have this quarantine for 14 days. The mean is about 5 days when they're not actually contagious anymore. So as long as they're symptom free for 24 hours, they can come back to work. And the only other thing I would say is you really got to think about, you know, the perception in the workplace from someone testing positive, whether with your management team or if other employees find out, because you want to make sure that that person isn't mistreated in any sort of way as it relates to them contracting COVID, because you also have some obligations from a human rights perspective. And if that person felt like they were discriminated against because they tested positive, then you could be faced with certainly a discrimination claim that's submitted to the tribunal. So those are the main key points that certainly we would recommend that you be aware of if you've got a positive case in the workplace.
Yeah, and just to add to that, in the privacy as well, you know, this is a very stressful time for a lot of employees on the best of days, let alone if there's a positive case in the workplace. So, you know, obviously there would be a lot of concern if all of a sudden they become aware that there's a positive case, and likely a lot of finger pointing or a lot of detective playing going on to try and figure out who it is. It's very important, and just to echo what Janice said, is that you don't release the name of the employee unless they authorize you to do so, but you shouldn't put pressure on them to do that regardless. If they come to you and they say, I'm fine if you tell people it's all right, then you need to ensure that there's safeguards in place for that employee as well, and still make the decision as to whether or not you want to, and whether it's in the best interest of the business to do that as well. Because while you may have addressed that remedy, that privacy concern, there's still always the risk that the employee could face reprisals in the workplace, maybe not from management, but from other employees, harassment or bullying. And as an employer, you have a duty to ensure a toxic-free work environment. Otherwise, that employee could claim constructive dismissal on that basis, as well as that you didn't take the adequate steps or take the necessary steps to protect them from harassment or bullying in the workplace. And so I understand that there would be a lot of stress, a lot of panic amongst some of the employees trying to figure out, you know, who was it? Was I around them? But all you can do really is assure them that you've taken the proper steps to ensure that the workplace is safe, to disinfect the workplace, you know, and you've taken the adequate steps to ensure that they're able to continue working in the environment that they're working in. So that's just to add on to what Janice was saying. It's obviously in terms of, you know, what sort of repercussions there could be for an employer if the name gets out, or if the name's released, it will still have to be tested in court or at the tribunal. But previous cases that are not necessarily related to COVID-19, but that do address, you know, the protection of privacy of employees, would give a good framework for the courts to follow should this ever get to court. Okay, so I think we're at questions now. And so the first question we have, I don't know if Mackenzie, if you want to go through the questions or if you want me to go through the questions.
Sure, yeah, I'd be happy to facilitate.
Okay, sure.
The first question we have is, how should an owner disband their business and have any worth given to the beneficiary? I believe this was a pre-submitted question from the beginning, so I'm not sure who would be best to answer that, but how should an owner disband their business and have any worth given to the beneficiary is the question that was asked.
I'm not too sure what's meant by that in terms of how should an owner disband their business. Obviously, there's legal requirements for any business looking to wind up operations to follow, you know, and there's obligations to ensure, you know, that your creditors are paid, that employees are paid their wages. But in terms of and have any worth given to the beneficiary, I'm not sure how. I think I need more information to answer that question. And certainly if there are any questions flowing from this presentation, I believe my contact information is on the front page of the slides. So feel free to reach out.
Absolutely. Thanks, Josh. The next question we have here, somebody's asking, are you eligible for CRB? Are you eligible for CRB, CRSB, or CRCB if you received the CERB in the past but no longer receive it now?
Janice, did you want to take that one, or I can jump on too?
Sure. Yeah, sure. Well, there's certainly eligibility criteria that you have to meet for any of these benefits, but you could potentially be eligible, but if you're eligible for unemployment insurance, they're really redirecting everybody to apply for the unemployment insurance, right?
Yeah.
Perfect.
And you can't receive obviously any other benefit as well, right? Like you can't apply for two benefits. You have to apply and stick with the one benefit that you'd be applying for.
Okay.
Yeah.
Is my small business eligible for CERS if I own the building and make mortgage payments rather than rent payments?
The CERS is a rent and mortgage support program. Full details haven't been released as of yet, and the program's not underway as of this moment, but it appears that it will be provided to property owners. However, limits or restrictions may apply. So I'd encourage everyone to stay tuned as to what the next steps are and what the actual program looks like. You know, the Prime Minister and Deputy Prime Minister have indicated that the CERS will fund up to 65% of rent or mortgage interest payments. There's speculation that this program may be limited to a subsidization of interest on the commercial mortgages. So just stay tuned as to when the program's actually rolled out. You know, it could have changes. It could include it. Most likely will, but it's hard to say for now, for certain right now.
Thank you. Somebody's asking, can my employer do they have the right to fire me if I refuse to wear a mask on the job?
I don't know if you want to take this one first, Janice, or I can jump in.
Either or, Josh. Go ahead, and I can add.
All right. All right, sounds good. So there is an obligation on the employer to ensure, under the Occupational Health and Safety Act, a safe work environment. And the public health officials have come out with clear evidence that masks do protect others. So it's really dependent on your work situation. Your workplace can provide policies that require employees to act in a certain way to ensure the safety of all fellow employees or customers. For example, lots of workplaces, if not all, have a policy where you don't show up to work intoxicated, especially when you're operating heavy machinery. Right now, we're in the midst of a global pandemic. So, you know, this hasn't been tested in court yet, whether or not a wrongful termination was justified by virtue of the employee not wearing a mask during a global pandemic. But if your work has clear policies with respect to the occupational health and safety component of its operations, and part of that component is to adhere to the requirement to wear a mask and or to wear a mask as per guidelines from the Public Health Office, then certainly there may be grounds, but there needs to be certain steps that are taken too before they can terminate you, and whether or not it would constitute just cause is another story as well. So there's two types of terminations. There's terminations for cause and terminations without cause. And your employer doesn't need to have a reason if they're terminating you without cause. They just need to provide you with the appropriate notice or payment in lieu of notice. So under the terms of your employment contract and the Employment Standards Act. If they're trying to fire you for cause for not wearing a mask, then there's steps that they need to take to ensure that they've adequately warned you that your conduct is in breach of the workplace policies that you agreed to in your employment agreement. There's an effort to coach you to wear a mask, and then that you've continued to fail to adhere to those requirements despite instructions from your employer to do so, and despite the public health interest to do so. So in those circumstances, maybe it's justified, maybe it's not. But I'll let Janice jump on that. And I apologize if you hear a dog in the background.
I just wanted to add too, I think it's important for everybody to either emphasize with their team or be aware of that, like, the Occupational Health and Safety Act is based on joint responsibility, right? So it's not just the employer that has legal responsibilities, it's also the employees. Right. And it's very clear that the employee is legally responsible under the Occupational Health and Safety Act to adhere to all the company's safety policies, including wearing personal protective equipment. In this case, a mask would constitute personal protective equipment in order to protect the employee from the hazard, and in this case the hazard is COVID-19. So you should also be aware of that as well.
Perfect. That's a great point. Thanks, Janice. The next question we have here is they're wanting to know if both their partner and themselves can take turns claiming CRCB.
Sorry, I'm on mute. As long as another individual from your household is not claiming for the same week and you're not in receipt of paid leave from your employer, you may submit a claim. Applications do not renew automatically. You must apply for each period separately, meaning you and your partner could take turns if your job permits it. Janice, I don't know if you've heard anything separate. It's kind of a unique program that's just rolling out, so there might be some maneuvering or some sort of changes to it, but I don't know if you've heard anything differently or anything to add to that.
Yeah, no, that's pretty much what we know at this point too as well.
Perfect. My place of work is still operating, but I have chosen to keep my kids home from school and have to stay home myself. Can I be fired for this? Janice?
Well, I was just going to say that actually is something that's frequently has come up, and that employers are dealing with. And so right now that would be a reason and that was a change that was made to the infectious disease emergency leave, where you would then be deemed to be on that job protected leave. And so, yeah, ultimately an employer can make a decision of whatever they want to do, but there's consequences to doing that. So if they did terminate, then, you know, that would constitute a reprisal under the Act. So that would be problematic. And the Ministry of Labor frowns and Labor Relations Board frowns on that. The one thing that I think some people think that they're, again, going back to what I mentioned before, that they think if they chose to keep their kids home and wanted to stay home to homeschool them, that there is a benefit out there through CRA or through employment insurance that would cover them for that. And at this point, there isn't anything like that in place. So it would be an unpaid job protected leave.
Yeah, and just to add to that, Janice, and you hit the nail on the head there. From a legal perspective or from a lawyer's perspective, I would love to argue that case for wrongful dismissal because it's, I mean, the optics are terrible. That, you know, you're keeping, I mean, we're in an uncertain time. You know, not everyone wants to put their kids back into school because it poses a risk to your loved ones. We don't know the long-term repercussions of COVID-19 either. I don't think anyone does. So if you have that concern and you want to take the safer route and keep your kids home and curb the spread of COVID-19, but your employer is trying to require you to return to work, despite the different legislative initiatives from the provincial government to provide job protection to those who have to take that leave. You know, at the end of the day, and just say your child has a respiratory illness or is a compromised immune system, right? There's a whole bunch of different factors that go into these decisions. So it would be a very, very difficult case for an employer to make to justify the termination of an employee on that basis.
Somebody's asking here, our company has adopted a mandatory work from home policy in response to the global COVID-19 pandemic. What are best practices for compensating employees for the expenses they have incurred as a result of working from home? Perhaps Janice, you could touch on that.
Yeah, well, employers can certainly issue a T2200, I believe it's what it's called, where the employee through, when they're issued their T4, you issue a T2200 for that claim period. And then they can certainly claim some of maybe their personal expenses, their home office through their tax application, right? Where other employers are instituting in their policies a certain maybe minimum dollar amount for cell phone coverage if they have to use their cell phone, or they're allowing them to take home some equipment from the workplace as well if they don't have, you know, maybe a workstation or a second screen at home. So I think there's different, certainly different options you could consider in a scenario like that.
Awesome. Yeah, I think I also just heard the government was rolling out that if you were at home for, say, or still are at home for the past 6 months to claim on your taxes for the new year, there was a form that could be filled out by your employer and for you to be able to claim that expense of sorts.
Yes, yeah, that should be the T2200. Don't quote me on the T2200. It's been a long day, but I'm pretty sure it's that particular form.
Awesome. Josh,
I think you're right. Yeah. No, I think she's right though on the T2200. So.
Okay.
Can I tell employees who are over age 65 to stay home from work for their own protection?
Ooh, no. That's a human rights complaint in a nutshell right there. You do not have the right to discriminate against an employee on the basis of age, sex, orientation, anything along those lines, any protected grounds, and age is a protected ground. And really, you shouldn't have to send them home for their own protection. If you're complying with the Occupational Health and Safety Act, taking the necessary steps to ensure a safe work environment for your employees, then age should not be a factor. Wear masks, physical distance, disinfect, clean. Encourage those behaviors at work, ensure that they're implemented and enforced at work. So that way it doesn't matter about someone's age. Someone's safety at work doesn't depend on their age. Because I can assure you that if you were to tell them not to come to work on the basis of age, you're going to have a significant legal issue on your hand.
Mm-hmm.
Perfect.
The only other thing too is, in addition to that, I think everybody should be aware, like certainly the public health department is highly recommending with bold letters, underline, that in any of your common areas within your workplace, as we, mind you, it's been a beautiful weather week, but as we are all working now inside and maybe not working from home, it is critically important that people do wear masks in common areas. So washrooms, hallways, and those areas too as well. So you might want to make sure you've got those practices in place if you're concerned about maybe some vulnerable workers.
Yeah. And not only those practices in place, but actively and regularly communicate those practices.
Yeah. Right.
Communication is so key right now. If you don't actively remind people, the joke is now when you go into the grocery store, you have to make sure you have your keys, your wallet, and your mask.
Yeah.
Because we're not used to this. We're not used to having to wear a mask everywhere in the halls. And I've caught myself too when I'm at work, going to go to the washroom and I forget my mask. So I immediately go back, grab my mask, and then you can go about your business, right? You can go down the hall, you can talk to your colleagues, but just make sure it's communicated on a regular basis because sometimes people forget. We're not infallible. So that way, if you have these policies, and you need to have these policies, make sure that these policies are communicated so everyone's on the same page. And if there's any questions, you can address them earlier on as opposed to after any sort of incident.
Yeah, that's a great point, Josh. I love that. And I feel like most people, if they do forget their mask now, you just instantly feel so flustered because that's supposed to be the norm, but people do forget and we are humans. So I think communication is key. It's such a good point. Somebody's asking here, mental health has been on the rise as a result of the pandemic and working from home. I know we're all feeling it. As an employer, what would you suggest that I do to help my employees with this?
There's certainly a number of things that you could potentially do. I think certainly the first thing is being able to recognize the signs and symptoms of employees that have concerns from a mental health perspective. And, I think it's having an open conversation and offering your support in any way that you can. Make sure that if part of your group insurance benefit, you have an employee family assistance program. Make sure that this is the perfect time to make sure that that 1-800 number is posted in your lunchroom, on your bulletin boards. It's a perfect time to do a Zoom training session with your EAP provider so that they can offer some resources and support for your employees. If you don't have an EAP program, that's not an issue. There's a lot of really great resources like Bounce Back and different programs that are free resources that you can make available in your workplace as well. So, I think it's frequent check-ins, Unfortunately, we've seen a lot of situations where employers have disbanded their workplace, they're working from home, people are feeling isolated, but they haven't kept the communication going. And people like to work in social environments and have social interaction for the most part. So, you know, if you don't have a regular meeting format or a regular communication process in place, then make sure that you get that in place, because as we enter the winter season, you know, January, February are the months where people, you know, are affected by and can get seasonal affectiveness disorder. So plan ahead to make sure that you've got things in place to help them.
Yeah, and you know, if you have a benefit provider, obviously, you know, as Janice was mentioning, to contact them. I know, you know, at Barriston, we've acknowledged or recognized that this is going to be a very tough time. We're going into winter, which will probably compound on people's mental health issues or any concerns that they have or the way that they're feeling. So we're arranging for webinars for our employees, you know, to encourage them to participate in a safe and secure manner in different mechanisms that can assist them with coping with COVID, you know, how to cope with the winter that's coming up, you know, because this is a lot of pressure on anyone. I find, you know, you talk to a lot of people, they're working, if they're lucky enough to continue working their business, they're working more than ever. Yeah. You know, Janice was mentioning how busy she was today, and I know the same has been with us here at Barriston as well. You know, we're trying to get back to clients as quickly as possible. There's a lot of moving parts. So a lot of our staff are working really around the clock, and we're trying to encourage people to how to separate. When you're working at home, it's hard to separate home from work. Yeah. So coming up with mechanisms on how to do that, you know, but just being there for your employee, to communicating, right? I think a lot of, as I mentioned in earlier seminars and today, you know, communication is so key to ensuring that, because if you can't control how someone feels at home, but if you can take that one added stress of, okay, what's going on with work, because that's a huge factor in people's lives. And if you can take that stressor out of their life and say, just through open communication, say, listen, this is how we're doing, this is what we're doing. You know, you're a valued member of our team. If you do that, that could reduce a lot of the stress as well. And, you know, I think would go far in improving, you know, with an employee who's maybe dealing with some mental health issues or concerns, and helping them deal with that as well.
Absolutely. Those are some great suggestions. Thank you. We have time for one last question here. Somebody's asking, if I had to lay off employees at the beginning of the pandemic, but now I want a majority of them to come back, but they don't want to because they are collecting government funding and don't want to work, what should I do in this situation?
Janice, have you dealt with that one before?
Yeah, too many times.
Yeah, I know, you mentioned it.
Oh my goodness. Well, they couldn't, you know, it was very clear, certainly when CERB was in place, that, you know, the CRA, although they really were very quick in processing the payments in the beginning, that if they were very clear that people can't refuse to come back to work. And so, you know, I know they set up a line where you could actually report it. I believe it probably still is in place as it relates to these other 3 CERB benefits, but they can't refuse to come back to work just because they've got you know, a government paycheck, right? So Josh, did you want to add to that?
No, you know, you're right. I mean, it's not to provide a windfall to employees or you know, taxpayers. Like, this is, you know, and you're going to have to account for the amounts later on in your taxes as well, because it is an income. But it's not to, the goal was to allow employees who were impacted by COVID-19 and layoffs to be able to afford their, you know, their rent or their mortgage payments or their groceries, their heating bill. So the goal was not to leave anyone out in the cold. Well, that goal is met if the employer needs the employee back, and we need that for an effective continuation of commerce in Canada, right? So as Janice mentioned, there is that hotline that you can call. You know, but you have a right to recall your employees following the layoff. In fact, it could be dangerous if you don't, you know, because they could treat it as constructive dismissal later on as well. So recall, and if they refuse to do so on the basis of CERB, make sure that you document that. And if you want to take the next step, you know, I would say consult with a lawyer or consult with your HR professional as to, okay, how do I treat this employee? Because in some cases, some employers don't want those employees back to begin with. But in this case, it sounds like you do. So I would suggest making that call, and because they're not allowed to benefit from CERB if they do have employment to go back to.